Welcome and good morning to all the eminent panelists and ladies and gentlemen. So today we had three presentations. They were very informative and enlightening, insightful. Those are the words I would like to describe these three presentations. Jayanta touched on the salient features of the Personal Data Protection Act, and Roshan about the challenges faced by SMEs in implementing or complying with the Data Protection Act, and then Asela spoke about the benefits of complying with the Data Protection Act. So as Asela mentioned, complying with these acts is not a matter of compliance, it's a matter of sustainability of companies. He also went on to state that an SME is defined as an entity which has a turnover of less than 750 million and a staff or employees of less than 300 to 250 employees. Now, SMEs in Sri Lanka play a vital role. It's the engine of growth. That's what Asela stated. SMEs constitute nearly 80 to 90% of all businesses in Sri Lanka. In terms of employment, they constitute about 45% of total employment, and they contribute 52% of the GDP. In terms of export income, they contribute over 20%. And we must understand that SMEs in Sri Lanka are mostly rural based. And in this country where there is a need to increase export income, these SMEs need to integrate into the export supply chain. And complying with all these standards, Cybersecurity Bill and the Personal Data Protection Act will certainly help these organizations to expand their markets, especially to overseas territories. Having said that, my first question is to Jayanta. I would like to ask you, Jayanta, now you were involved in formulating this piece of legislation, and you would have met a lot of stakeholders, even from the SME sector. Can you just give us some insight about their mindset or in terms of their preparedness or readiness to comply with this stringent piece of legislation? I would like Roshan and
Thank you, Ashane. Thanks for that super introduction you gave. Yes, there were mixed reactions when we had stakeholder discussions on the bill. But what was important is that there were 7 rounds of multi-stakeholder discussions on the piece of law before this became a bill. It becomes a bill when it is gazetted based on the constitutional certificate given by the Honorable Attorney General. So that process was preceded by a very thorough vetting, and I must say there were stakeholders who were reluctant to meet the obligations, and the definition of an SME can vary from folks having different perceptions about how do you define the quantum of value of that would meet the threshold of an SME. In some countries like Australia, they have put it down to somewhere around a company that earns less than 50 million Australian dollars. I'm not too sure exactly the amount, is excluded from the ambit of the data protection law. However, there are consumer protection instruments through strong consumer protection authorities in those countries that regulates SMEs of that nature. Now, there was a debate even here whether this law is all-encompassing, it will cover SMEs, and what is the value proposition this would bring. And it is in that context, Ashane, that I just want to emphasize, given the mixed feelings, a strategy was formulated to delay the implementation of the law over 18 to 36 months. But more importantly, B, what was done as a strategy in this bill, which is now a law, is to bring in a soft law measure whereby the regulator will not impose sanctions in the first round. After a fair hearing, they would impose directives, and those directives are also subject to challenge in the Court of Appeal, and that would ensure that an SME would not be burdened with the cost of a regulatory action. So that's one way in which we got over the problem, but I am mindful of the fact that when you say this stringent piece of law would have a burden on SMEs, well, SMEs are bound to benefit. Also, as Asela said, if they create more trust and confidence for consumers to use their ecosystem. So it's a two-way street kind of scenario, but I would end the point here by stating that most of the SMEs who were consulted in the final rounds agreed that there is a need for a law that would enhance consumer privacy, because the consumer protection laws in the country have not adequately dealt with the subject. So we need to have a sub-law that is all-encompassing, but give room for them to adjust. And finally, on the mitigation methods, if they have a data protection management program running in their organization, then they would benefit tremendously when it comes to a regulatory hearing, because under Section 39 of the law, compliance with the minimum set of obligations that Roshan also mentioned that would come under a data protection management program would be a mitigation factor when it comes to imposing fines if there is a further violation.
Thank you, Ashane. And on the same line of the discussion, I would like to say why we have the Compliance and the Data Protection Act would help, and why you need to be compliant on that. Just to give you a simple example, just I thought of it right now. Like when we drive, we're supposed to wear seat belts. So initially it was told that, okay, if you wear a seat belt, your life can be saved and in case of accident. So how many people voluntarily wore their seat belt while they were driving? Very few. But then there was a law came in that saying if you are not wearing the seat belt, you will be fined. So then all of a sudden people will start wearing seat belts. So now obviously if you looked at the statistic, there are supposed to be a good number of lives saved because you are wearing a seat belt. Of course it have a cost involved in it, because for each and every vehicle you're supposed to have a seat belt and all kind of a thing. So in the same line, if you think on this particular Data Protection Act and so on, when you want to implement it, yes, there will be some cost involved in it. Regular reviews have to be done. Technological changes you need to adapt to, and the cost will be involved in that. But then you need to consider a cost if there is a breach, and what would be the cost of reputational damage and loss of businesses. So if you weigh those two together, then obviously the reputational damage and loss of businesses and things will be a huge number. Obviously a huge number. So because of that, you need to comply into that. Once you are compliant, then obviously there are added advantage of getting more businesses, more trust on your business, and so on. So that's a simple example that I can tell you on this particular discussion that we are having right now. Just to make sure that you are compliant into that means that it is an added advantage. You need to look at that advantageous point and the way forward, then only you can go along with this particular line.
Asela, would you like to elaborate on the benefits of aligning SMEs aligning with the Personal Data Protection Act? If you like to elaborate.
Before that, I think previous question you asked, I had the opportunity to sit across the table for the drafting committee because as part of SLASCOM, I looked after the review from SLASCOM's side. So I wanted to attest how open the committee was, because I recall section 26 was not worded the way it was worded now. It had a fairly far more far-reaching, I would say, implications to the industry. But the committee was open for it, and I do appreciate that. Just to again come back to that question, Facebook was another entity which was a little jittery, if I recall, is the word, Jayanta. But I think their position was, listen, globally we have to be compliant. And as far as the Data Protection Act or the Personal Data Protection Act was concerned, it was seen as a globally benchmarked. So for them it was easier. The same view was shared by Google. If you look at the advantages, primarily if you look at the stats you just quoted for an SME, it will give them an opportunity to have better market access, especially to the US and the EU. Because we know the EU and the US now have signed the Transatlantic Data Partnership. So GDPR is sort of a same standard, if I believe, Jayanta, across both countries. And there is some work, like Jayanta mentioned, in US to come up with a federal law for data protection. Now, one of our key markets, if you look at our export mix, is the US and the EU. So we must do everything within our power to ensure that SMEs, who are our key dollar earning entities, be compliant to any standards they put across. A good example is the garment industry. The apparel industry has very stringent quality controls, very stringent sustainability controls, now privacy controls, and therefore they have become a leader in the region when it comes to that particular sector. Similarly, what we want to encourage the SMEs is, listen, like Roshana also mentioned, put the investment in. I'm sure agencies like USAID can also help with the initial investments. But once you have those protocols in place, it becomes infinitely easier for you to get access to those markets versus any other competition. Remember, India does not at the moment, I know there is work on it, Jayanta, but India at the moment does not have a privacy legislation. We are the first country in South Asia, and we must be very proud about that. Because of that, we have an advantage, and a trade advantage. Future trade will be determined along the lines of data privacy. We're already seeing that. Data privacy, the flow of data, is no longer an IT issue. It's a trade and a geopolitical issue. And I will touch upon that if there is a question. But in order for us, we don't need to get involved in those matters, but in order for us to benefit from this, especially SMEs, we need to be compliant. And that is the impression that we must insist on. And if we do that, we will be successful, and this will be a thrust to get us out of this crisis.
Jayanta, this next question is to you. Now, Sri Lanka passed the Right to Information Act in 2016. And given the provisions of that law and the PDPA, which is the Personal Data Protection Act, do you feel that there is a competing interest, on the one hand, to disclose because of the RTI, and on the other hand, not to disclose, given all these new privacy laws? How would a data processor controller deal with a request for information under the RTI? What policies should be in place to deal with this situation? So I would like to remind the audience also, if you do have any questions, you can pose it to the panelists.
Thank you, Ashane. So on the issue of right to information law intersecting with the Data Protection Act, there was an extensive debate on this subject. Ashane, during the public consultation period, it was very interesting because during the public consultation round, even the Right to Information Commission and the journalistic groups were strongly advocating some kind of checks and balances that would ensure that the right to information safeguard is protected. So, a bit on the Right to Information Act, I think we should be aware the fundamental right to information guaranteed to a citizen is to a citizen of the country, not to any natural person impacted or benefited by the Data Protection Act. I said earlier, Data Protection Act benefit accrues to not only to a citizen, but only to even to a visitor that comes to the country or any outsourcing entity processing data on behalf of a company in Europe or US or Canada or Japan or Australia. So it protects foreign nationals in the same manner it protects Sri Lankan nationals. Right to Information Act is a right given to a citizen of the country to access information with a public authority. The original right is guaranteed through the 19th Amendment, Article 14A, but the Right to Information Act provides the tool and the mechanisms to make it possible, and it actually governs not the private sector, but impacts the public sector, public authorities as defined in the Right to Information Act. Now, in terms of the Data Protection Act being a potential impact on the Right to Information Act, that debate is a continuing debate, Ashane. But I just want to give some comfort to my friends in the Right to Information advocacy groups, because I myself was part of the Right to Information Act drafting committee, and some people are of the view that some of the public interest override provisions are too broad, giving the Right to Information Commission sweeping authority to compel disclosure, even violating privacy of persons working in a public authority. But that debate will go on for some time. But how this law gives a kind of a measure of or a semblance of benefit of implementing the Right to Information Act is through the concept of lawful processing. I mentioned that one of the key features of the Data Protection Act is the principles of processing data. The first principle of data processing is lawful processing of personal data. Now, the criteria for lawful processing is defined and illustrated in Schedule 1 to the Data Protection Act, and one of the paragraphs makes it clear that it will be lawful to process if it is necessary to comply with the legal obligation to which the controller or processor is subject to under any written law. So which means, when you translate in practical terms, in relation to a public authority governed by the Right to Information Act, if you as a citizen, Ashane, makes a request for a piece of information that would relate to an individual in that organization holding public office, for example, asset declarations or something like that, then the processing of that request can be lawfully done by that public authority under Section 5, read with Article Schedule 1 to the Data Protection Act. So which means there is a bit of harmonization between the two. And finally, in terms of processes and practices, policies and organization would have to put in place to make that happen. I just want to close the discussion by saying again, reminding the audience that the Right to Information Act only applies to the public sector, public authorities, provincial councils and local authorities, and therefore those entities would have to have data classification, categorization mechanisms in place. And that is an essential component that would ensure safeguards in terms of security practices as well, and proactive disclosure where required under the Right to Information law. So there's a connection between all of them.
So, are there any questions from the audience? I would like to request. Of course, yes, there's one question.
Thank you for the opportunity to ask a question. So I'm asking this from a perspective of an educator. And so when you take the law, one of the key things is that just because you're ignorant of the law doesn't make you exempt from the law. So that should apply to the act that you were talking about as well. So what I'm asking is, were there during the discussions, were there any discussion which related to making SMEs and the general public aware about the law, and how, of course that won't be a provision in the law itself, but just to make them aware, because as mentioned in some of the presentations, Sri Lanka is still very reluctant in adapting technology, so that should apply to that should contribute to the reluctance in adapting cybersecurity measures as well. So were there any discussion with regard to making SMEs and the general public more aware about the law when those discussions on the law itself are taking place? Because I know it was mentioned that there is a provision that the first offenders are not penalized in the first round. There is a provision that there are only directives given. So even before that, were there any discussion on making the public aware?
Thank you for your question. I think Jayant and perhaps Ashane can provide.
Yeah, thanks for that question, and that's an extremely valid point from a policy implementation perspective. Those who are engaged in law drafting often sometimes are disconnected with the practical implementation aspects often, but many of our stakeholders pointed out the need for broader targeted awareness. Now, having said that, I must say that right through the drafting process, there was awareness campaigns being built up thanks to the work of SLESCOM, FITIS, Ceylon Chamber, and many other consumer groups as well. But there ought to have been more. Normally, in a law of a country, one does not build in awareness, capacity building as a requirement for the implementation of a law. It is left to the implementing ministry to define a program of work to build capacity before the law is brought into effect. And one of the tasks of the future data protection regulator is to build awareness across stakeholders on the implementation aspects of the law. And I hope these information through FITIS and others will spread to the policymakers in this country, such as the Ministry of Technology. Ideally, they ought to have been here to hear the voice of the people who are talking about capacity building, because the Ministry of Technology is the one that would have to ensure proper implementation, starting by the Secretary himself. So to illustrate and conclude on the subject, the Right to Information Act went through a series of rounds of awareness campaigns across the provinces at the grassroots levels over many months, which was a very salutary measure that Ministry of Mass Media took at that time. And I hope the policymakers of the country would do the same thing prior to the implementation of this act. We have done our job. It's up to the new regulator and the professional groups in the country to lobby. Maybe ISACA also can do that, to lobby for broader awareness campaigns before this law is brought into effect. Thank you.
Thanks, Jayasekara. So I think there was one more question.
I'm Vidya, representing National Innovation Agency. I just wanted to know that there's a national data sharing policy and national data open data platform is coming up. That's what we have heard. So how this data policy, the Personal Data Protection Act, will have a work on this particular data sharing policy and this open data platform?
I will ask Ashane to answer specifics of how it can be effectively done. But on the legal side, data sharing, data classification is a foundation step for the implementation of data protection laws in a country. Because if you look across the various provisions in this act, including cross-border data sharing under Section 26, which means the ability of a business, government or entity or a private sector entity to host data in cloud services. The classification and categorization of data has been introduced as a necessary condition for cloud hosting, right? So it works positively as a foundational step in relation to data protection law implementation, number one. Number two is that in terms of the Right to Information Act, in terms of proactive disclosure, categorization and classification would demarcate the boundaries that will guide an organization based on the question that Ashane asked earlier. Basically, was the policies and measures an organizations should put in place. So I think the point you raised is the foremost answer to that question. If you have done that categorization or classification, it would help an organization in their disclosure abilities under the Right to Information